You didn't leave fingerprints, there's no video, there's no recording, there's no DNA, but guess what? One person's statement can still lead to your arrest and a conviction. That's right, one witness, one person's testimony, and you're convicted of a crime. But how is that possible? It's he said, she said, because testimony is evidence. I'm Diane Bass. I am a criminal defense attorney and I represent people who are facing serious charges, many of which are based purely on witness testimony. In today's video, we're going to talk about what qualifies as evidence in a case and why a single witness statement without any other evidence can lead to an arrest and ultimately a conviction. If you or someone you love is in that position, don't wait. Getting the right legal advice quickly can sometimes make all the difference. So what counts as evidence? Evidence includes physical items, digital records, documents, and yes, witness testimony. That is one of the most powerful forms of evidence that prosecutors rely on. Let's break it down. A sworn statement is enough to convict someone. A witness statement that's given to law enforcement can often and does often lead to an arrest. That same witness statement in court can lead to a conviction. Testimony in court is considered evidence. If someone testifies that they saw you commit a crime, that is often enough. So if a witness makes a statement to law enforcement at the scene of a crime, law enforcement will write a report. They will submit that report to the DA's office or the U.S. Attorney's office. The prosecutor decides if they're going to file charges based on those statements, and oftentimes they will file charges and ultimately can get a conviction just based on that witness's testimony. Let's use a domestic violence example. If someone calls the police and they say that their spouse hit them, that is enough evidence to have the spouse arrested. If that person then testifies at trial, that is enough to have the spouse convicted. Even if there's no video or if there's no recording of the incident, the neighbors didn't see anything, it doesn't matter. People always say, but that's hearsay. It's he said, she said. It's not hearsay. And yes, it is he said, she said. So even if a witness heard a conversation, but they didn't actually see what was happening, but they heard the person charged with the crime saying something that's against their own interest, that can actually be used in court to convict somebody. Whether the statement or the testimony holds up in court is a whole different thing, but when it comes to getting arrested, that's enough. Not every statement gets into court. There are limits.
It's hearsay. It's all he said, she said.
People say this to me all the time, but that's hearsay when they're talking about an alleged victim's statement. Not if they were present, not if they heard something, not if they saw something. They can testify about that. It's not hearsay. Hearsay is defined as an out-of-court statement that is offered to prove the truth of the matter. Hearsay statements are generally not admissible unless they fall under one of the many exceptions, like an admission of a defendant, a statement made by a defendant against their own interest, a spontaneous utterance, a dying declaration. These can all be used against you. There are many exceptions to the hearsay rule. It would take me hours to explain them all. We do a year of evidence in law school. It is one of the most complicated areas of law. Suffice it to say that what a witness heard or saw, we can always challenge the credibility of a witness's statement by using their prior record, if they have a motive to lie, or if they have a record of lying. This was called impeachment, but that only goes to how much weight their testimony carries, and that determination is made by the jury. So if you're being investigated or you've been arrested because of something that someone else said, don't assume that nothing is going to come of it. And don't assume that the government doesn't have a case. They do. Even if it's just a statement, that can be enough to take away your freedom. But that doesn't mean that the case is solid. That's where I come in. I have spent decades cross-examining people. I have exposed uncredible testimony, even of FBI agents. And I know how to protect your rights. If you're facing criminal charges, call me. The earlier I get involved, the better chances I have of getting ahead of the government's narrative. Let's talk before things go any further.